Hello everyone. In this lecture, we are going to discuss about contract documents. What are their requirements? What are the details to be included? And also a little bit about dispute management in contracts. So, in the drafting of a contract, we'll have to first understand the different contents of a contract document, a standard contract document. So, it needs to have all the drawings and specifications very clearly mentioned, citing all the items and also citing all the various regulations such as IS codes, IRC codes, etc. Then the bill of quantities and pricing is to be very clearly mentioned. Bill of quantity means the different items and their estimated quantities to be used in various elements or various components of the project, and also the pricing, that is the price that has been agreed upon after signing of the contract, after the contractor who got the award of the contract, and based on his pricing this contract document will be drafted. Then the plan and program of construction, that is which task is to be done first and which tasks are to be done by whom, at what place, at what time, all those things are to be formulated and drafted in the beginning itself as much as possible. Then quality management plan is another aspect of a contract document, where what kind of testings are to be done in different materials and different construction elements and components, and who is going to conduct all those quality assessments and how they are to be assessed, what happens if something fails this kind of quality assurance plan or requirements. Then the health and safety plan for workers and all the other employees involved in this project. Then also the general and specific conditions or provisions of a contract. That is, in general, for all the contracts, some conditions are prevailing, but in a particular project, some specific provisions may be there. So all those things are to be very clearly mentioned. And finally, the risk insurance or risk management. So if something goes wrong, what will be done? What will be the step necessary? Who will be responsible? What will be the compensation? And all those things are to be included in this contract document. So rather than describing all these things in very detail, we'll only look at very critical aspects of this contract document. So the first one may be the parties and their roles. The parties in this case may be authorities, then contractors, and what are their responsibilities, what are their rights, and also the hierarchical organization of both contractors and the client are to be very clearly mentioned. This means who is in command and who is answerable to whom. The proper chain of command is to be very clearly mentioned. Otherwise, it's unclear to anybody whom he or she has to report and who are their subordinates. So this structure has to be very clearly mentioned in the contract documents. Then comes the scope of work. Now, scope of work or scope of any item means that, for example, if you mention installation of a elevator or lift in a building, then how much does that scope cover? What is the scope of that work? Is it only installation of the machinery, or is it also does it also include installation of the security cameras, all the electrical components and all those things? So it has to be very clearly mentioned. Similarly, in case of a even in a very simple task like fitting a kitchen sink, is it just fitting the kitchen sink, or the plumbing work and sealing of joints, waterproofing and all those things? Those are also included in the scope of work. So those things are to be very clearly mentioned. Then variation of scope means that sometimes whatever was mentioned in the contract document, in the field you may see that it may vary. That means some additional items may come in and some items may not be necessary. When you may find that some items may not be necessary when you go to the field. So what will happen when the scope varies? Similarly, again, uncertainty in the field work, they may also come into picture, because sometimes the field survey may not be properly done, and it's very possible, because if you go for a very large project, field survey in a very detail is not possible. So in that case, what will be the step to be taken? Let's try with an example. If a certain excavation work is to be done for, suppose, a boundary wall, then the excavation part will be for the footing, and this much earth is to be excavated. But if the field survey is not very detailed, then you will not know about the soil conditions, and when you go to the field, then you may find that instead of cohesive soil, you are encountering cohesionless or sandy soil. So in that case, this kind of a cut cannot be made in the soil, and you have to make the cut like and a sloping cut. So in that case, this extra amount of excavation is to be carried out by the contractor. Now, is it included in the contract document? And if such a thing is encountered, what will be the next step? So all these things are to be very clearly mentioned, and if they are not, then they may lead to lots of disputes in the future. Another critical item is the proper description of items. For example, if we are considering a brick wall and the item description is the plastering of the brick wall, then you may write as plastering of brick walls on both sides, but it's not a very good description of the item, because we know that generally when a brick wall is constructed, one side of it is properly aligned, the brick faces are properly aligned, but that is on this side. But on the other side, because of the irregularities in the bricks, this side is generally rough compared to the other side. So in that case, we have to properly describe the entire item in such a way that it has to be 1/4 cement and sand mortar plastering of brick wall, 10 mm thick on the finished side, that is on this side, since it is already smooth, so the thickness of the plaster is not that much, but on the other side it has to be 15 mm, and therefore, so these things have to be clearly mentioned, and along with covering any remaining exposed brick surfaces. So it may be important in case of a brick wall in a room. In a room, you will also have a window or door. So if there is an opening like this, where you will have to fit a window here, then after fitting the window, then these surfaces will be exposed. Now, this is a very small amount of plaster to be done, but it may require some time. So all these things are to be very clearly mentioned, so that the contractor takes into account of these difficulties, and although the material cost is negligible, because it requires time and the contractor has to pay the masons some extra money because of that extra time, so he or she may adjust that by slightly increasing the price quoted for plaster. Instead of, suppose, 20 rupees, he may quote 21 or 22 rupees, which is not much, but it takes care of the extra time for which he has to pay the masons. This is a very simple example. Generally, these kind of mistakes are not made, and even if these kind of mistakes, that is, if you just mention plastering as plastering on both sides of the wall, the experienced contractors will themselves correct it, that these are to be clearly mentioned. Then other requirements are time. So in case of time, we have to be very specific about what is the time of commencement or beginning of a certain task or the entire project, when it should end, and if there is any delay, what should be the penalty of for that delay. Will it be some kind of monetary penalty or some kind of other penalties? And also the responsibility for the delay. If something is delayed, who is responsible for that? Sometimes it may be client. Suppose in some cases, some materials may be provided by the client instead of being procured by the contractor. So if the client makes delays in supplying those materials, in that case the client will be responsible for those delays, so the contractor cannot be held accountable. So all these things are to be again included in the contract documents. Then price. In case of price, ceiling or the upper limit of pricing is to be mentioned, because in very large projects, by the time you finish the project, the price of various items or various materials may increase, and because of that, may be because of just general increase in price for external reasons, or because of general inflation and so on. And if you want to take into account the inflation, then how much inflation are you going to consider? Because we cannot predict what will be the inflation in the next 3 or 4 years, so it has to be decided what will be the formula. And in these kind of formulas involving economic predictions, some kind of index are also to be used. So these index values, whether they will be constant indexes or indices, or they will be variable indices, those things are to be again mentioned in the contract. The base date. Base date means if you're projecting the future price of an item, then what will be the base date? Is it today, or is it from the beginning of the commencement of work, and so on. And tax and duties are also to be discussed and mentioned in the documents. Taxes may be income tax, or taxes to be paid on materials procured, and so on. Sometimes, almost always, in institutional funded projects, when you pay the bill to the contractor, generally some amount of tax is already deducted from the bill, and if at the end some remaining tax is to be paid, then the contractor will file for income tax separately by himself. If the tax paid by the client at the source is more, then the contractor will get some tax return, and if it is less, then the contractor will have to pay additional taxes. And how much tax will be deducted with each bill, and all those things will again to be included. Then comes risk sharing. So in risk sharing, one term that is used is force majeure. Now force majeure is something, some incident or some happening which is unforeseen or unavoidable, and which cannot be controlled by either the client or the contractor or any other stakeholder. So in that case, it is very necessary to define exactly what kind of incidents or disasters may be considered as force majeure, and what are the scopes, and what are the plan of action or relief. For example, the first example here is the flood in case of a place like Assam. If somebody is considering building of a bridge over a river. Now, if the contractor is trying to construct the bridge in the summertime, which is the peak flood time, now can it be considered force majeure? Because it is well known that in from June to August or September, it is the flood time in Assam, and in that case, if some damages may occur because of flood, will the client or anybody be responsible for compensation of the damages to the contractor, or the contractor himself will be responsible for repairing all those damages? Similarly, in case of an earthquake as well, what kind of an earthquake can be considered force majeure? And the scope of this force majeure clauses will also have to be very clear. That means if the construction works that are completed about 3 or 4 months ago, if those items fail or those constructions fail in an earthquake of moderate magnitude, suppose 6 or 7, 6 or 6.5, while they are supposed to be designed for considering an earthquake of 8 magnitude, so in that case it should not be considered force majeure. But the construction that are very fresh, that is the freshly cast concrete and so on, so those will definitely get damaged in a moderate earthquake, because the concrete will not develop its full strength. So in that case, the fresh constructions may be under the scope of force majeure compensations, but in case of the old constructions, they may not come, or they should not come under the scope. Then we can come to insurance. Insurance is something where we expect that something may go wrong and some damages may occur. So in that case, some insurance agencies or companies will compensate for our damages, but for that we'll have to pay some premium. Now, the idea of the premium is that we'll pay some small amount, so and only if something goes wrong we'll get the compensation, but if nothing goes wrong, then the insurance company or insurance agency is not liable to pay us the money back. Again, there coverage again includes the scope, what kind of damages or what kind of incidents are covered under insurance, how much should be the premium, and how much should be the coverage. Again, accidents versus negligence. If something goes wrong, the insurance company will also want to check whether this incident has happened because of unavoidable circumstances or because of negligence of some persons. And also, I'll leave this question open to you to check who pays the premium. Is it the contractor, or is it the client, or is it any other stakeholders such as investors? Now let's come to dispute management. Many times, although generally people try to avoid them, disputes do arise in management or in execution of a contract. So they generally arise due to faulty design or drawing and item descriptions, as we have already discussed in one of the previous slides. If you do not describe the item properly, if you do not take into account the different possible field situations and so on, then there will be dispute between, or there will be a conflict between the contractor and the client. Then faults and ambiguity in drafting of clauses. These clauses may be what to do when something happens. So if those things are not very clearly mentioned, if the language is not proper, there may be double meaning sentences. So because of those situations, some additional conflicts or disputes may arise. Incorrect data or information, we have already seen this in case of that artwork example, where the information or the data of soil conditions was maybe mentioned as clay or cohesive soil, but when you go to the field you see that it is cohesionless soil, and you have to do some extra excavation for which you will not be paid. So in that case you may face this kind of disputes. Then price fluctuations, if prices fluctuate too much and we have not already taken into consideration of those possibilities, then also some disputes may arise. Natural disasters, as we have seen, may also cause some dispute. Then interference of other contractors may sometimes cause hindrances in the execution of a project. Sometimes subcontractors who will be working under the main contractor may also raise some issues, and those may also lead to some disputes. And then of course corruption is a major concern for which different disputes may be possible. Now whatever may be the cause, we need to resolve this kind of dispute, and for that there may be various stages or various levels of dispute resolution. So the first one is mediation or conciliation, which is a very informal process. Then arbitration is slightly formal, and jurisdiction is when the case is fought in the court of law. So we'll study them one by one. So mediation is an informal process where a neutral third party or third parties assist in resolution of the dispute. So they will give you some suggestion that if this is the case, you are confused in interpreting this kind of a clause and so on, so you can do this, or this kind of a solution can be adopted. So for that, the neutral third party will have some kind of expertise in this kind of in the domain of the construction industry, and it's up to the other parties, that is the client or the contractor between whom the dispute was escalated. Then they will decide whether to take this suggestion or not. That means the mediators do not give judgments, and the results of mediation is not enforceable. Whatever suggestion is given by the mediators, either parties may not like it and they are not bound to follow it. So therefore it's a very informal process, and generally for small disputes, generally both parties try to resolve the disputes in this stage itself, because it's quite quick and simple. But sometimes if the solution is not acceptable by one of the parties or both the parties, so in that case we go to the next stage or next level, which is arbitration. So an arbitration is quite formal process, and it's a quasi-legal process. It means it is like legal process but not exactly legal, because it's not done in the court of law but in a different formal setup. So a neutral third party again carries out assessment and gives a judgment. Now the difference between the previous mediation or conciliation and arbitration is that instead of giving a suggestion, the arbitrator will give a judgment in favor of either of the parties. So the arbitrator will have to have some technical knowledge of the domain so that he understands the problem and then give a judgment. Then knowledge of contract laws and law in general is required, and the judgment given by the arbitrator is generally binding. That means it is enforceable by the party against whom the judgment is awarded. Now if the judgment is accepted by both parties, then they will accept it and act accordingly. So documents will be signed in the presence of the arbitrator and both the parties or their representatives and witnesses, and later on that will be carried out, put into practice. But if the judgment given by the arbitrator is not acceptable by the party against whom the judgment is awarded, then they may challenge this judgment and challenge it in the actual court of law. So in that case, we'll have to go to the next stage, which is jurisdiction. We'll get to that later, but before that, let's discuss some duties of the arbitrator or roles of the arbitrator. So once the arbitrator is appointed or invited to resolve some kind of dispute, he or she needs to check their own qualifications so that they're confident enough that they understand the problem and they have the ability to assess the whole situation and give a fair judgment. Also, there should not be any conflict of interest. Conflict of interest means if I am the arbitrator and I'm giving a judgment in somebody's favor, it should not appear that I'm against the other party because of some other reasons and other interests that I have. They may be business interests or personal interests. For example, if an arbitrator who is an expert in some field, who is currently appointed by either of the parties, should not be appointed as an arbitrator. Similarly, they should not be personally related, and so on. Also, the arbitrator generally does not personally investigate the case. So the arbitrator will not meet witnesses or examine evidence in absence of either of the parties. And all this involvement of the arbitrator will be only in presence of both the parties in a very formal setup. And also the arbitrator cannot delegate authority. That means if one is assigned or appointed as an arbitrator, he or she cannot appoint somebody else to do the work on his or her behalf. And also the scope should be maintained, that is, the process should be confined within the scope of the dispute. That means if a certain dispute is arising in the for example, the dispute is in the item of earthwork, then they should not generally discuss another item where dispute may be even there. But if that dispute is not discussed in this setup or this process, then the other issues should not be brought to discuss the current issue. So those are some limitations or some roles or duties to be performed by the arbitrators, and some points to be kept in mind. Now, if the arbitration fails, or if the judgment given by the arbitrator is not accepted by the party, then they can go for the next level of dispute resolution, that is jurisdiction or in the court of law. So here a case will be filed by the party who was raising the concern, and it will be processed in the court of law, and the decision is binding if it is given by the court, by the judge, unless it is challenged in a higher court. That means if you are resolving this in a district court and if you are not accepting the judgment, then you can challenge it in high court, and if it is not resolved in high court, then you can go to Supreme Court. Now, it is generally avoided in most cases. We generally try to resolve all the disputes possibly in the mediation stage, and if that is not the case, we'll try to, as far as possible, settle the whole issue in the arbitration stage. And arbitration has lots of advantages because an arbitrator is generally a technical person with domain knowledge, and therefore they are suitable for technical disputes. Also, the place and time can be mutually decided, where in case of a court case, you will be called to the court on a specific date and time, and both the parties will have to be present, otherwise it's a contempt of court and so on. But in case of an arbitration, both the parties can decide that we'll sit on this office or that place and then invite the arbitrator. Again, the decision by the arbitrator or the judgment by the arbitrator can be imposed or can be binding, unless challenged, of course, which is not the case in mediation, where mediation is only a suggestion. And legal advice can be sought by the arbitrator, because sometimes if the issues escalate a little bit, then it may not be under his or her expertise to resolve those kind of issues, and additional help can be sought from some other lawyers or experts. Then site of work can also be visited. That means actual evidence can be examined in the site. What happens in a court of law is that it's very difficult to bring the judges or lawyers of the court to a site. And since we are talking about construction industry, something goes wrong in a site and the evidence will be on the site. And in the court of law, those evidences cannot be directly brought there and will only have to depend on photos or videos and so on. But in case of an arbitration process, because the place can be decided or site can be visited, so it becomes much more easier to get a better detailed understanding of the real problem. Also, finally, no publicity is involved generally in case of arbitration, because you don't have to generally, in case of a court case, the court will send public notices, and if it's a high profile case, there will be news items based on that. But if it's an arbitrary process, it can be private, it can be only between the stakeholders such as client and contractor and investors and so on, and therefore publicity is involved, and therefore lots of hassles and expenses are spared. Now, there are some rules for interpretation of provisions of contract in case of disputes. For example, if there are general conditions or provisions and specific provisions, for example, a general provision may be an IS code, which says that something has to be designed or constructed in such a way. But for a specific project, some specific provisions may be made. For example, if you remember your IS codes, in many clauses it is mentioned that the decision has to be taken by the field engineer or the designer or the expert, where IS code does not cite any kind of very specific measures or very specific numbers or figures and so on. So in that case, the general provisions are overridden by the specific provisions of this particular project. So if there is a dispute, which to follow, do we follow the IS code or do we follow the specifications provided by the designer for this project, then the specific provisions generally prevail. Then words versus figures. If an item is described both in figures or drawings and words, generally words prevail over figures, and that's because not everybody is very competent or qualified to understand civil engineering drawings or very complicated designs. So in case something is mentioned in both words and figures, the description mentioned in words will be prevailing in case of a dispute. Then clerical and typing errors, printed versus written words. If there are some errors, the corrections will be prevailing over the original typing or original calculations and so on. If something is printed on a document and after that if you correct it with a written word with your initials or signature, then the written words will prevail over the printed word, and that's quite obvious. Then another point is the benefit of doubt against drafter of the contract document. It is considered or assumed that the drafter or the writer of the contract document has a better understanding of the document or the phrases or the sentences written in the document, and therefore if some ambiguity remains, some discrepancy remains, then the other party who has not drafted or written the contract document will be given the benefit of doubt. That means their interpretation will be prevailing. So from all these discussions we have a general idea that in a good contract document it has to be using simple words and phrases. Then as far as possible it is advisable to avoid conflicting and ambiguous phrases and sentences. It's also important to clear the description of rights, responsibilities, authorities, and chain of command. Then legal advice during drafting of contract document is also necessary in case of large contracts, and these contract documents are sometimes they may be 1 or 2 pages, but for large projects they are very large documents, very voluminous documents, and it's always advisable that you take help of some legal experts to draft some clauses of these documents. And one more thing, that is the fair distribution or sharing of risks. Generally what happens in the Indian situation is that whatever is the risk, a major share of the risk is to be borne by the contractor, and that means if something goes wrong, if it rains heavily, then the contractor will be liable to responsible for all the damages. If something unexpected happens, then the contractor's interests are generally in many cases not protected. So if possible I'll try to prepare another lecture based on different types of contracts, different modes of contracts where these kind of things differ, this sharing of risks and responsibilities differ, and in some kind of contracts they are very much fairly distributed, and in many other contracts it is generally biased towards the client. Now, so this is all about the contract documents and the problems in contract documents, the requirements. I hope you have a brief understanding of this whole process, and we'll go into detail of 1 or 2 of these, all these topics that we have discussed in a little bit more detail in some future lectures. Thank you.